me see. Mr. Brady, how about 5 minutes? 10?
Maybe 5, maybe less.
All right, you let me know.
I'll let you know.
Do you want me to do the introduction while you're doing this?
Sure.
Okay. Good morning. My name is Judge Kathleen McCarthy, and you're here today for first appearance hearing, and there's 3 purposes for today. Number 1, the first purpose is Excuse me one moment.
That's what I was about to say.
Okay. System is on.
And this is another.
Excuse us one moment. We're having some technical difficulty.
Okay, that's an add charge. These are change of charges. What were they originally? See, usually what happens, sometimes they're like very, hold on, sometimes they're like.
Okay, we're good? Okay, excuse me, sorry about that. Again, my name's Judge Kathleen McCarthy, and you are here for first appearance hearing. There are 3 purposes for this hearing. The first purpose is determine if there's probable cause for your arrest, which means whether there are reasonable grounds to believe a crime may have been committed, and you are the person that committed the crime. If I find there's no probable cause for your arrest, one of 2 things may occur. I may give the state up to 24 hours to produce additional facts to show probable cause, or I may direct you to be released. If you are released for lack of probable cause, it does not mean the case is over. It only means you will be released from custody. If the state wants to proceed against you on the charges, it has the right to do so. The second purpose is determine whether you should have a lawyer appointed to represent you. You have a right to counsel, and if you have your own attorney and you want him or her present, you should advise me, and I will direct the bailiff to attempt to contact him or her. If we cannot reach your attorney, however, this proceeding may be delayed. If you would like to have the public defender appointed to represent you, please let us know. I will appoint a public defender to represent you if you qualify for his services of the public defender. You must fill out completely an application for indigency, which will be provided to you, and the clerk of court will determine if you meet the statutory criteria for having a public defender appointed to represent you. Please note you will be charged $50 for the processing of the application, which is due 7 days from the date of the application. Please understand, the services of the public defender are not free. If you eventually enter a plea of guilty or no contest, or if you're eventually found guilty of the offense for which you are charged, then a judgment may be entered against you for the reasonable value of the public defender's services. The third purpose is determine what type of pretrial, if any, should be set in your case. I also want to advise you that each of you have the right to remain silent under the Fifth Amendment to the United States Constitution. You're not required to say anything, and anything you say may be used against you. You also have the right to communicate with counsel, family, or friends, and if necessary, you will be provided reasonable means to do so. Jeremiah Miller?
Mr. Miller is going to be a medical reset again, Judge.
Okay. Insocencio Rosado?
Is that Mr. Miller?
Yeah.
Oh, he is here. Okay, okay.
Hello, Mr. Miller. Sorry, we thought you were in a medical reset. Sir, you're being held on 2 charges. The first one's aggravated battery causing bodily harm or disability. The second charge is false imprisonment. State?
I got it. 1 moment, Your Honor.
Okay.
Does pretrial have any notes on Mr. Miller as far as criminal history? Okay. Your Honor, based on the level of violence alleged in this case, state would be requesting bonds in the following amounts: $7,500 on count 1, $2,500 on count 2, with an order of no victim contact.
Mr. Romero?
If I could have about a couple more seconds to speak to Mr. Miller, Judge?
Yes.
Thank you.
Arrest warrant. The first thing you're going to look for is you got the actual warrant, but you don't have the is the explanation of what the allegations are. So here's how you can find it. However you get your documents, do a search under the name. This is a good example. This is a common name. Now, you're going to look for something that's logged. Okay, sorry we haven't filed it. Notice the incident date's October 11th, so it's going to be some offense date is around then, presented date.
Thank you, Judge.
Oh, 10/11.
Judge, in speaking to Mr. Miller, he's been residing in South Florida his entire life. He's 36 years old. He told me that he previously worked in 2006 for a furniture company. Unfortunately, he's no longer working there. He's right now applying or going through the process of applying for disability, so he has no income coming in. The alleged victim, I did tell him this is domestic situation, Your Honor, is going to be imposing probably a no contact order. He understands. He's going to abide by that order. He's going to be living separate and apart from the alleged victim. He's specifically going to be living with his cousin who resides in Broward County as well. Judge, he's a single father. He has 6 kids. Right now, financially, from what he told me, he has no sort of capability to post a bond. I asked him if the person that he's going to be living with, his cousin, is going to be able to afford to post his bond. From what he told me, he doesn't think so. Judge, at this time, I'd ask you to take into account his financial resources, strong ties to community, his lack of any criminal priors. I'd ask you to consider setting a bond on count 1 of $2,000 and on count 2, $1,000, Judge.
Okay, thank you. The court's going to go ahead and find probable cause with regard to charge number 1. Bond will be set at $5,000. Charge number 2, bond will be set at $2,500. Sir, you're to have no contact with the victim. Do you understand?
Yes, ma'am.
Okay, neither direct or indirect. Do you understand? And you're to remain at least 500 feet from the victim until further court order. Do you understand? And additionally, you're not to possess any firearms or ammunition.
Yes, ma'am.
Okay. Anything else, State?
Nothing further from the state, Judge.
Okay. Good luck, sir. Inocencio Rosado?
Very serious stuff.
He's here, President.
Good morning, sir. You're being held on violation of probation, and you have a hearing scheduled in Division FV for your VOP on January 2nd at 9:45 a.m.
Thank you, ma'am.
All right, good luck, sir. Carter Lee Sims.
Mr. Sims is here, President, Judge at Maine.
Okay, good morning, sir. You're being held on 2 charges. The first one is burglary with assault or battery. The second is touching or strike, battery, domestic violence.
Talk to you for a second.
State?
Your Honor, after reviewing the probable cause affidavit, the state would be seeking a no bond hold on count 1, which is a punishable by life offense, versus under Isaza v. State for first appearance purposes only. Your Honor, noting the allegations contained in the probable cause affidavit would satisfy the elements of burglary with assault or battery. Also noting multiple witnesses in addition to the alleged victim corroborating the victim's version of events. Your Honor, also noting I have great concern not only for the alleged victim, but for the child, with allegations that Mr. Sims threatened to kidnap the child and made a threat to, one moment, Your Honor, that he would be coming back with a gun.
Your Honor, in order for the court to hold Mr. Sims without bond, this court would have to make a finding that the proof is evident and the presumption great. That is the highest criminal justice standard that we have. We would submit that the state has failed to meet that burden. All that they have produced this morning is a probable cause affidavit. A probable cause affidavit is designed to do one thing, and that is to establish probable cause, one of the lowest legal standards that we have. The state has called no witnesses. They've introduced no physical evidence. All they have done is present the court with a several-page probable cause affidavit. And while case law does state that the court can find probable cause or proof evident presumption great based solely on a probable cause affidavit, our position is that this one is insufficient. The case that the state cites, Yasada v. State, is a very strong probable cause affidavit. It includes multiple witnesses as well as a confession. That element is not present here. Mr. Sims apparently gave no statement to the police from what I can see. So this probable cause affidavit is insufficient for establishing proof evident presumption great, and we would ask the court to set bond for Mr. Sims.
Anything else, Steve?
Nothing further, Your Honor.
Okay, sir, the court's gonna go ahead and find probable cause. With regard to number one, the court will set bond at $25,000. And with regard to number two, the court will set bond at $2,500. Sir, you're to have no contact with the victim, either direct or indirect. Do you understand?
Yes, ma'am. Your Honor, based on the threats that are contained in the probable cause affidavit, the state would be requesting pretrial release level 1.
Granted. Okay, sir.
Judge, I understand as far as the state's request, as far as a level 1. Level 1 would basically be locked down. Mr. Sims would be prevented from actually working. I'd ask you at this time to consider a level 2. He is currently working. He works actually 3 jobs. He works for a tile and grout cleaning company. He works for Funky Buddha, and he works for a pressure washing company. Judge, he actually lives in Coral Springs, separate and apart from the alleged victim. His monthly rent is about $1,200 a month. If he's not allowed to work, he's gonna lose his apartment. At the very least, at level 2, we'll still ensure pretrial knowing where he is with the monitor at all times. He would only be allowed to go to and from work, but that would allow him to still keep his apartment, Judge. So I'd ask you at this time to consider, instead of a level 1, a level 2, Judge.
Your Honor, based on these threats, including kidnapping a child and threatening people with a gun, I believe the risk he poses is too great for even level 2, Your Honor.
Okay, so again, the court will impose level 2 at this time. Sir, you're to have no contact with the victim, either direct or indirect. And you're to remain at least 1,000 feet away from the victim pending further court order.
And, Your Honor, we would also ask for a no contact order. I don't have a full name, but for the minor child that
Yes.
is mentioned.
Absolutely. Sir, you're to have no contact with the minor child until further court order as well. Do you understand? Mr. Romero, will you explain it to your client?
I'm explaining him right now, Judge.
Okay, thanks.
Your Honor, you did advise level 2.
Yes.
Thank you, Judge.
Okay, sir, you're also not to possess any firearms or ammunition. Do you understand?
Yes.
All right. Franklin James Record.
He's here, main Judge.
Hello, sir. You're being held on 2 out of hold for, let's see. Pennsylvania, sir. Okay? Good luck.
I was here on that Sims case for Josh Rydell, but I missed it, so.
Oh, no.
Thanks for giving him a ball.
Oh, I'm sorry, Mr.
missed
Weeks.
it
I
by
didn't
what, a
realize you were on that.
Oh, that was it, okay. Sorry, John. It's okay.
Okay.
What was it, Judge? I can tell.
25,000 on count 1, 2,500 on count 2.
Level 2, no contact with the victim or minor child.
Thank you so much.
Okay. Shalimar Diana Wright?
She is in,
Hi, Judge.
Hello, ma'am. It looks like you're being held on a KP's traffic. State?
Judge, I know she would like to resolve this if possible this morning.
Sorry about that, Judge. This is Ms. Wright?
And Mr.
Yeah.
Reedy, this is for the obstruction of traffic?
It's
Yes, ma'am.
panhandling.
Okay.
Your Honor, Ms. Wright does have a criminal history. The state's offer to resolve the case today would be adjudication time served.
Did you hear that, ma'am?
Yes.
Do you want to resolve your case today?
Work there, 'cause-
Yes, please.
Okay, please raise your right hand.
Okay.
Do you solemnly swear or affirm to tell the truth?
No, they're not.
Yes, all true.
Okay, is anyone forcing you to resolve your case today?
No.
Okay, are you under the influence of any alcohol or drugs?
No.
Do Do you suffer from a mental or an emotional illness which would impair your ability to understand what's going on today?
No, Judge.
All right. Do you understand you're waiving your right to trial?
Yes.
All right. And you're pleading no contest to the municipal ordinance?
You got it, Bo.
Is that correct,
one.
ma'am?
You got it.
Yes, yes.
Okay, so I accept your plea. I find it is freely and voluntarily given. The court will adjudicate, sentence you to time served, and you'll have 12 months to pay your court costs.
What's the court cost?
Hey, Omar,
What's the court cost?
Hold on, ma'am, how much? $293, ma'am.
$293?
Yes. All right?
Okay.
All right, good luck. Cachet Bruton? 12 months? Hello,
Ms.
ma'am.
Bruton is here present, Judge Jermaine.
Okay, all right, ma'am, you're being held on 3 charges. The first one is false ID given to law enforcement officer. Second one is possession of cannabis, 20 grams or less. And number 3 is a capious misdemeanor.
Judge, Ms. Bruton is requesting if Your Honor would consider resolving her case today.
One, I just want to, I'll certainly make an offer. I just want a moment to
Hold
check
on
her
one
record.
moment, Mr. Romero.
Thank you.
Your Honor, I see no adult history. Well, I'm sorry. I see a prior MO. If Ms. Bruton wants to resolve these cases, the state's offer be a withhold court cost judicial notice of time served on all counts.
Mr. Romero, how's that sound?
Ms. Bruton, I was just explaining to her, and she wishes to accept the state's offer.
Okay, very good, ma'am. Please raise your right hand. Do you swear or affirm to tell the truth?
Yes.
Is anyone forcing you to resolve your case today?
No.
Are you under the influence of alcohol or drugs?
No.
Do you suffer from a mental or emotional illness which would impair your ability to understand what's going on today?
No.
All right. And you understand you're waiving your right to trial?
Yes.
And you're pleading no contest to charge number 1, false to ID given to a law enforcement officer, correct?
Yes.
And no contest to the possession of cannabis, 20 grams or less, is that correct?
Yes.
Okay, ma'am, I accept your plea. I find it is freely and voluntarily given. The court will withhold adjudication on both counts. Take judicial notice of time served, and you'll have 12 months to pay your court costs. Good luck, ma'am.
Thank you.
On the capious misdemeanor? We'll also withhold adjudication on that. Take judicial notice of time served. Christina Rossi.
Good morning, Your Honor. Mr. Rossi is at the Paul Ryan.
And
You're-
we're gonna do
she's
Miss
at Paul-
Christina Rossi?
Yeah, I think she's at Paul Ryan.
Okay, and then if you could apprise the court with this
Absolutely.
case, please?
Yes, Your Honor. Your Honor, this is an ad charge and change of charges. Ms. Rossi was originally arrested, and I'm just checking to see what. She's got, she had bond surrenders on a drug paraphernalia. On this arrest, she was originally arrested for DWS third or subsequent robbery with a weapon that was downfiled to a felony theft, and another felony theft on a separate case, and she was charged with this aggravated assault.
Okay.
Your Honor, I provided the court with a copy of the original probable cause affidavit. Additionally, Ms. Rossi's priors include battery. She pled a felony down to misdemeanor battery in 2015. Theft 2010, possession of cocaine 2010, she violated probation. Theft 09, unlawful use of false name identity and theft 09. Theft 09, possession of cocaine 07, resisting without violence 04, DUI 05, possession of alprazolam, and DUI 04, she violated probation. Burglary and theft 03, possession of alprazolam 03, she violated probation. Based on her criminal history and the allegations that she allegedly attempted to hit someone with her vehicle, state would be requesting a $5,000 bond in order of no victim contact.
Mr. Brady?
Your Honor, Miss Rossi's currently being held on a $10,000 bond on count 4. She's not been able to post that. I doubt very much she's going to be able to post any additional bond on this.
It's a $1,000 bond.
Oh, is it? I saw 10,000.
No, gave an extra zero.
Okay, sorry about that.
All right.
I'm getting a little old. Miss Rossi, you been able to post a $1,000 bond or $6,000 bond?
No, Your Honor.
Is there anybody I can call to come get you?
Maybe my mom,
What's mom's name?
Esther,
What's her number?
754-234-2398.
How much money do you think she'd be able to come up with?
I don't know. I know that on the robbery charge, it was a $10,000 bond, so it was $1,000 and she didn't have
Yeah,
that.
I thought it was a $10,000 bond.
It's
Yeah,
not. The
that's what it
robbery,
was saying.
It's not, okay. It's not a $10,000 bond.
robbery was down filed.
Yeah,
Okay, hang on. All right, I'll give your mom a call and see if she can come get you, okay?
all right, thank you.
Okay, you're welcome.
Okay,
I'd ask for a $1,000 bond, Judge.
okay, the court's gonna find probable cause. We'll set bond at 2,500.
I'll call your mom.
Mary
All right,
Jones?
thank you.
Mary Jones? You're good. Hello, Miss
Mary
Jones.
Jones is here present, Judge?
Do you need a moment, Mr. Romero?
No, I don't, thank you, though.
Okay. Ma'am, you're being held on 3 charges: tampering and first-degree felony proceeding, 2, aggravated stalking following harassing and cyber stalking, and number 3, using two-way communication device to facilitate felony.
Your Honor, first, on count 1, I would note that count 1 is actually a punishable by life offense. And I understand the judge, and I couldn't read the signature, so I don't know what judge signed the warrant, but a $10,000 bond was set. We would still be asking the court to make a finding of proof evident or presumption great for tampering a first-degree felony, specifically tampering and threatening the alleged victim. Well, I guess you can't say he's alleged anymore since I believe her brother was, I know at least her brother was convicted for attempted murder of that victim. Threatening the victim of an attempted murder, where Ms. Jones is currently was out of custody on bond and pretrial, charged in the attempted murder of that individual as well. If the court is not inclined to make a finding of proof evident or presumption great based on the judge putting a $10,000 bond, then we would ask for bonds in the following amounts. We would ask for, on count 1, $150,000, count 2, $100,000, count 3, $50,000. Should she be released, pretrial release with a GPS monitor level 1 in order of no victim contact, no contact with her co-defendants. Your Honor, not only is Ms. Jones a threat to the community, but specifically this alleged victim, she is, based on this evidence, is interfering with the legal process. She is seeking to destroy the legal process in this attempted murder case by threatening victims or the victim of this crime and noting the evidence against her, that this allegedly occurred the day after she testified in her brother's case.
Well, my concern, Judge, would be that a previous court has already reviewed these matters and made a determination as to what an appropriate bond in this case should be. I don't know that there's anything new being presented here this morning to you that wasn't previously presented to the judge who decided that these other bonds were appropriate, as to count 1 and as to count 3 in any event. Maybe Mr. Romero can give us some more insight as to what type of bond she might be able to afford on count 2. But I would certainly object to this court making a finding of proof evident presumption great based on the fact that a previous court has reviewed this matters and declined to make that finding.
Your Honor, and Mr. Reedy's aware of this, no court ever makes a finding of proof evident or presumption great on an arrest warrant because that's not the standard for issuing an arrest warrant. And if Mr. Reedy's arguing that, well, the court should follow the bond set by the judge, I would note that the court set no bond on count 2. Now, obviously, and even though the court said no bond on count 2, Mr. Reedy would argue, and I would agree, she's legally entitled to a bond on count 2. My point is just because the court sets a bond on the arrest warrant doesn't mean that the court has to follow it. And all I'm asking the court to do is follow the law. If the court determines that there is proof evident presumption great, I'm just asking the court to follow the law that she should be held no bond on a punishable by life offense on count 1.
Okay. All right, thank you. With regard to charge number 1, the court will keep the bond at $10,000. With regard to charge number 2, yes.
Judge, in reference to count 2, before your honor announces a bond amount, in speaking with Ms. Jones, I would like to give you additional information as far as her financial situation and her ties. She's 33 years old, been residing in our community for about 28 years right now. She's working right now. She's a waitress. She's been working for about 1 month, so she gets an hourly salary plus tips. She lives in Fort Lauderdale with her grandparents. She's a single mother. She has an infant child about 11 months old. Her grandparents, one of them is retired. Her grandmother actually works at Walmart. So financially, she can't come anywhere close to posting any sort of high monetary bond as far as what the state is requesting. I understand your honor as far as you've already ruled on count 1 as far as the $10,000. I'm asking in reference to count 2 if you would consider imposing a bond of $7,500 along with count 3. That would be a total of about $18,500. We feel that's reasonable on Mrs. Jones' behalf.
And Your Honor, just to invite, I believe if the court were to set the bonds at the amounts Mr. Romero suggested, her bond would actually be less than she got for the attempted murder when it was an aggravated battery, meaning that she gets a lesser bond for committing new law offenses while she's out. And I didn't see this at first, I want to bring to the court's attention, as far as the danger to the community that Ms. Jones presents. In 2007, she was convicted of aggravated assault with a deadly weapon. She violated her probation and was sentenced to just over 21 months in Florida State Prison.
Okay, thank you. Ma'am, with regard to charge number 2, your bond will be set at $25,000. With regard to charge number 3, that will be set at $1,000. Ma'am, you're to have no contact with the victim. Do you understand? Neither direct or indirect.
Yes, ma'am.
You're not to come within 1,000 feet of the victim pending further court order. Do you understand?
Yes, ma'am.
And Your Honor, based on these allegations, I would also ask, one, for a condition that she's not allowed to be in possession of any smart devices.
Okay. All right, ma'am, you're not to be in any possession of any type of smart devices. Do you understand?
Yes,
What else,
ma'am.
mister?
And, well, Your Honor, the state also had requested if the court was going to impose bond, that, well, are you going to be asked, making?
Yes, Your Honor, are you going to be revoking her pretrial duties?
I'm not going to be doing that. I'll allow the assigned judge to do so,
Then
if that's what they wish to do.
Your Honor, the state had made a request, if the court were going to impose a bond in this case, that she posts that she be supervised by pretrial with a level 1 monitor. She was on a monitor, correct? She was on a monitor at the time of this, so we'd ask that be increased to level 1.
Yes, that we will increase it to level 1. Okay.
I didn't hear the last, I believe
Mr.
your honor's
Linder?
imposing.
Hold on.
The court imposed pretrial GPS level 1.
If she makes bond, sir.
I understand, Judge, but as you know, level 1 would be total lockdown. That would be preventing her from working, and as I said, she's a single mother raising an 11-month-old child. I don't know if Your Honor would reconsider and impose
Right.
a level 2.
Based on what I've heard, and I believe that this is going to be the best thing for the public at this time. Thank you.
Yes, Judge.
Danae Yanke Young?
She's in North Broward, Judge.
Morning, ma'am.
Good morning.
You're being held on criminal mischief? State?
Your Honor, I'm just checking to see if she has any record outside of Broward, because I believe, based on the report, she resides in Jacksonville. I don't know if she was residing with her grandparents. I'm going to be requesting a no-contact order, so she won't be able to reside there.
Your Honor, she does have history in the state of Florida.
Okay.
2010 theft by shoplifting, she was convicted. 2011 theft by shoplifting, convicted, and 2011 DWI.
She was also arrested in Georgia last year for a failure to appear in court.
All right.
Your Honor, I'm going to be requesting that, based on the level of damage and allegations and her record, that the court, and lack of ties to the community, that the court keep the $500 bond in place in order no victim contact.
Your Honor, Ms. Young really has no way to bond out on a $500 bond, and the state is correct. She doesn't have the strongest ties to the South Florida community. Most of her family are in the upper part of the state or in Georgia. I am going to ask the court to sign an order allowing her to have access to her property. There are phone numbers in her phone that she might be able to call and get somebody to come and bond her out.
Okay, the court will grant your request, Mr. Rady, for the phone order. Okay, ma'am, the court finds probable cause. We're going to set bond at $500 in this case. Ma'am, you're to have no contact with the victims. Do you understand?
My son, ma'am, my son is with them, so I will have to have contact with them to get my son. My child is with them, my 3-year-old child.
Your Honor, we'll contact DCF. I'll contact DCF, but I'm sorry. I mean, because first of all, we don't know what is and isn't accurate, and to give any permission to go back to that residence at this
Right,
point
ma'am,
could
at this
result in.
time, you're to have no contact with the victims, either direct or indirect. Additionally, you're to stay at least 500 feet from the victims until further court order, and you're not to possess any firearms or ammunition. And if you have some issues with any type of childcare, I believe that the state is going to ask DCF to assist.
And Your Honor, specifically, because I don't have information regarding the child, what I'm going to do is I'm going to speak to the officer that made the arrest. If he has the information, he can contact DCF. If he doesn't, I'm going to ask him to go back to the residence to look into that.
Okay, all right, thank you. Good luck, ma'am. Lynn Dakiri Squires?
She's approaching, Judge, she's here at me.
Hello, ma'am. You're being held on 3 charges. The first one is distributing, delivering hydromorphone. The second one is distributing delivery of hydromorphone, and the third one is a capious misdemeanor. State?
One moment, Your Honor. Imagine that. Mackenzie, do you have anything other than the charge that was dropped in 2014? No record, Your Honor.
Okay. Romero?
Judge, in speaking to Ms. Squires, she believes her son will bond her out, but she does not believe he can afford the $5,500 that's currently set. Judge, in reference to count 1 and 2, I'd ask you to consider reducing the bond from $2,500 to $1,500 each count. She thinks a total of a $3,000 bond on counts 1 and 2 will be something that her son will be able to afford. So based on her lack of any criminal priors, Judge, this being a nonviolent offense, that's why we'd be asking you to consider $1,500 on count 1 and count 2.
Okay. The court's going to find probable cause. We're going to grant your request for the bond amount of $1,500 on count 1 and count 2. Anything else, State?
No, Judge.
Thank you, Judge.
Nordia Nicole Ann Taylor?
Ms. Taylor is approaching, Judge. Come on up. Judge, she declined the services of public defender.
Understand.
Good morning, ma'am. You don't want to use Mr. Romero's services?
Yes, I didn't understand the first time. It's my first time here.
Okay, no problem. Mr. Romero?
If I can have a brief moment to
Yes.
speak to her, Judge.
Okay, no problem.
Mackenzie, I don't see any, like, not even peaches and beef, nothing. I don't think she's been here. Do you have any notes?
Thank you, Judge.
Okay. All right, ma'am, you're being charged with grand theft auto, State?
Your Honor, I think it's just grand theft.
Oh, correct.
Yeah.
Let me correct myself. Grand theft, ma'am.
I don't see any history, but I don't see really anything on my database with regards to Ms. Taylor. I spoke with pretrial, hoping that they might have some information they got from interviewing her as far as how long she's been living here and whatnot. But unfortunately, she refused their interview and refused pretrial.
Judge, and speaking with Taylor, I don't know if there's any sort of confusion. I know when I spoke to her initially, I guess she was letting me know because this is the first time her coming before any sort of these similar types of proceedings. She just really was really confused, didn't really know what was going on. Judge, she was working at Publix. She informed me she lost her job. She's currently right now living in Tamarack. She's a single mother raising a 7-year-old daughter. She advised me she really doesn't have any sort of money to post this $1,000 bond. Judge, I know initially when I guess she was spoken to by pretrial, she declined. I believe I'm gonna try and advise her at this time to reconsider that and maybe apply for pretrial. And if pretrial can verify her address, considering her financial situation, I'd ask her to I ask Your Honor to consider releasing her on pretrial release.
Your Honor,
Yes.
she declined the pretrial interview twice.
Okay, Mr. Romero, pretrial said she declined the interview twice.
And they also explain who they are. They don't just come up and say, hey, can we talk to you? And noting, I think it's worth noting, you know, because Mr. Romero's arguing her financial situation, she doesn't have a job because she allegedly stole over $1,200 from her employer.
Judge, I understand as far as, like I said, pretrial twice tried to ask her. I even asked her before as far as public defender. And
Okay,
she
that's, I
legitimately
understand,
didn't
Mr.
understand.
Romero, I understand. Okay, so she can get out on pretrial pending verification, but we'll leave that 1,000 bond in place, okay? Pending verification.
Thank you.
See if third time's the charm.
Nicholas Adam Chamberlain?
It's on the R1.
He's here present. Morning.
Hi, sir. You're being held on 5 charges. First one's a capious misdemeanor. Second one's another capious misdemeanor. Third one, capious misdemeanor. Fourth, capious misdemeanor. And fifth, another capious misdemeanor. And it appears you do have a status hearing in your division on December 26th at 9 a.m. State?
Sure. Oh, I'm sorry.
Your Honor, the state would offer, well, I can only offer it on, one second, on count 3, but I'd offer adjudication time served.
Judge, Mr. Chamberlain wishes to accept the state's offer, and as a friend of the court, he's also asking me if Your Honor would also consider offering a similar type of plea offer for counts 1, 2, 4, and 5 as well.
Okay.
And I know those are municipal ordinance cases.
Okay, sir. Please raise your right hand.
Yes, ma'am.
Do you swear or affirm to tell the truth?
Yes, ma'am.
Is anyone forcing you to resolve your case today?
No.
Are you under the influence of any alcohol or drugs?
No.
Have you ever been treated for a mental or emotional illness which would impair your ability to understand what's going on today?
No.
Okay. Do you understand and you're waiving your right to trial?
Yes.
And you're pleading no contest to all the alleged crimes, correct, sir?
Yes, ma'am.
All right, I accept your plea. I find it is freely and voluntarily given. The court will adjudicate on all counts with time served, and you'll have 12 months to pay your court costs, okay?
Thank you, ma'am.
Yeah. Put this in the back? Okay. Sure.
Page 15, Your Honor, Ross Weiner on behalf of the state.
All right, hold on one moment. Can you help me find this one? He says it's on- What page, sir?
Page 15, Thomas Blankenship.
Okay.
Thank you, Your Honor.
Mackenzie.
There's a separate investigation.
Okay, sir. Thomas Gordon Blankenship?
Judge, he's in the restroom right now. If we could put on brief recall.
Okay. Johnny Laver Gutierrez?
Mr. Gutierrez, come on up, please.
Good morning, sir. You're being held on 2 charges. Number 1, you have a capious misdemeanor, and number 2, you have an out-of-county hold from Miami-Dade County for an underlying petty theft case.
Visualizing. $5,000 bond. And a $3,000.
Mr. Romero?
Sure.
And I-
He informed me he's gonna go ahead and post his bond.
Okay, and I just wanted to let you guys know that there's 2 different addresses that I see here for Tamarack, so we need to make sure we have his correct address.
8200.
Okay, I have one that's 8200 Northwest 91st Avenue.
That's where he would be receiving his mail, his correspondence.
Okay, and it looks like the capious that was issued was for Fairview Drive.
He was previously living at the Bayview, now he has the 8200.
Okay, I just want to make sure that, so he can get all future correspondence at the correct address. Okay. All right, the court will find probable cause.
Okay. So, okay.
Oh, hello.
Blankenship on.
Who needs the Spanish interpreter, Hector?
Oh, Spanish interpreter? Mr. Carlos Ocampo, he is on page 12 of the docket, Judge.
Okay.
Supervising her and her supervisor. I didn't get any answer.
Okay, please raise your right hand. Do you solemnly swear to affirm that you will translate from Spanish to English and English to Spanish?
I do. Esteban Rojas.
Okay, good morning.
Morning.
Sir, you're being charged with number 1, possession of cocaine,
Señora, usted se le acusa en el primer cargo de posesión de cocaína
and number 2, operating without a valid driver's license.
y en segundo lugar operar un vehículo automotor sin licencia válida.
No criminal history, Judge.
No hay
What
antecedentes.
are you asking for, Mr. Romero?
¿Qué está solicitando, señor Romero?
Mr. Ocampo declined the services of public defender. However, as a friend of the court, he did inform me that he needed access to his phone to contact someone to post his monetary bond.
El señor Ocampo rehusó los servicios de los abogados de oficio. Sin embargo, hablando como amigo de la corte, sí puedo decir que me informó que necesita una orden para que le permitan acceso a su teléfono para que llame a alguien para pagarle la fianza.
Okay, so we'll grant that. The court will find probable cause with regard to charge number 1. Bond will be set at $1,000.
Bien, vamos a otorgar esa solicitud. Consideramos que existen indicios probables de delito con respecto al primer cargo. La fianza queda fijada en $1,000.
Okay, anything else, State?
¿Algo más?
No, Judge.
¿De la fiscalía? No.
Okay, good luck, sir.
Buena suerte, señor.
We're gonna find out, sir, if we have any, when Mr. Romero comes back.
Well, I did, but I didn't get an answer. I called you. All right, I still need to read what the hell happened here. No, it wasn't. Oh, Jesus.
Thomas Blankenship.
He's approaching, Judge.
Okay, hello, sir.
How you doing?
You're being held on 4 charges. The first one's aggravated battery with a deadly weapon. The second one is possession of cocaine. Third is resisting officer, obstruction without violence. And number 4, driving while license is suspended habitual. State?
Good morning, Your Honor. Ross Weiner on behalf of the state. Your Honor, Mr. Blankenship has a significant criminal history. Beginning in 2013, he had a petty theft. There's a 2014 petty theft, 2014 trespass. In June of this year, he was in drug court and he pled to possession of heroin, fentanyl, and THC. He also has many failures to appear. In 2013, he had a failure to appear on case 13-28056 TC10A, as well as 13-28064 TC10A. In 2011, he had 2 failures to appear on cases 11-53709 TC10A and 11-53713 TC10A. He actually has an open bench warrant out of Miami for DWLS in case 8599GVD. He has 5 prior DWLS convictions, 2 in 2012, 2 in 2013, 1 from October of this year. He currently has an open DWLS case in front of Judge Solomon in case 17-030249 TC10A. Your Honor, based on the defendant's significant criminal history and the facts of the case, the state is asking as to count 1 for the court to set bond at $100,000, as to count 2 to set bond at $5,000, as to count 3 officer without violence at $5,000, and count 4 DWLS felony at $25,000, total bond $135,000. The state would ask that should the defendant post the bond, the court place the defendant on level 1 pretrial with a GPS, that he be ordered to not consume any drugs or alcohol, to be subjected to random testing. He is to surrender his passport if he has one. If he doesn't have one, he is to fill out an affidavit attesting to not having one. He is also to agree not to apply for a new passport. He's also not to drive a motor vehicle at all. And the state would ask that the court order that the bond be fully collateralized rather than just signing a promissory note to ensure that the defendant's presence will be in court, considering his many failures to appear.
Thank you. Mr. Romero?
Judge, in speaking of Mr. Blankenship, from what the state is suggesting, that's going to be financially impossible for Mr. Blankenship. He's 27 years old. He's been residing here in Florida his whole life. He is working. He works for a company called Safety and Security Tech. He installs security cameras. He's been doing that for about over 10 years. He makes approximately $10 an hour from what he informed me as far as his 2017 total earnings are approximately $20,000. That's something financially impossible from what the state is suggesting he's not going to be able to afford. He lives with his mother in Fort Lauderdale. He's been residing in the same place for about 5 years right now. He's going to be contacting his mom to help post his bond, but still, from what he advised me, her funds are very limited. Judge, I'd ask you to leave the standard bonds in place on counts 2, 3, 4. We'd ask you to consider setting a bond of $10,000 on count 1. Mr. Blankenship said he was also, I believe, interviewed by pretrial. He knows as far as what a pretrial entails. He'll follow all conditions that Your Honor sets forth. So at this time, we'd be asking you $10,000 on count 1 and with pretrial on Mr. Blankenship's behalf.
And the only thing that I would add, Your Honor, is that this probable cause affidavit is pretty thin as to count 1. I think it's barely probable cause at all. It states that Mr. Blankenship crashed his vehicle into the victim's vehicle in the parking lot intentionally to cause great bodily harm. But there are no photographs brought here by the state to show the extent of the damage to the victim's vehicle. In fact, the probable cause affidavit references a separate Wilton Manors case number, and we don't have any information about that either before the court this morning. So for the state to come in and ask for a bond that is as high as $100,000 on count 1 based on this, I think they've got to do a better job, Judge, because this doesn't even go into any detail at all about the contact between Mr. Blankenship's vehicle and the victim's vehicle.
Okay, all right. The court does find probable cause with regard to charge number 1. Bond will be set at $25,000. Number 2, $1,000. 3, $100. and four, $750. And State?
Yes, Your
What
Honor.
were the special conditions? Could you just, we're going to grant your request, but I just want to make sure that the defendant hears it.
Yes, Your Honor, the request was that he be placed on level 1 with a GPS, that he be ordered to not consume any drugs or alcohol, to be subjected to random testing at his own expense, that he surrender his passport and agree not to apply for a new one. If he doesn't have a passport, he is to fill out an affidavit attesting to such. He is to be ordered not to drive a motor vehicle at all. And, Your Honor, the state was requesting that the bond be fully collateralized. Was the court ordering that as well?
No.
Okay.
Okay, thank you.
Thank you, Your Honor.
Judge, as far as, the conditions, we'd ask you to consider, as opposed to level 1, which would be a total lockdown, level 2, he has been working at the same company for over 10 years. Basically, he goes to work almost on a daily basis. Judge, we'd ask you at this time to impose a level 2 so that he could go to and from work. As far as the, passport, order that, state is referencing, Judge, he doesn't have one. He's never applied for one. Judge, I don't know if, the state said anything as far as he's a flight risk to flee to any other country or anything like that, so I don't really know what's the basis of that. But having said that, I know in the past, Your Honor could basically, swear, Mr. Blankenship in, and he could attest that he doesn't have a passport, and that he'll follow your court order as far as not applying, for one, so I don't know if there would be any need as far as him filling out some sort of affidavit, presenting it to the clerk's office before he's allowed to go ahead and basically be released.
Okay. Sir, please raise your right hand. Do you swear or affirm to tell the truth?
Yes.
Sir, do you currently have a U.S. passport?
No, I do not.
Have you ever applied for a U.S. passport?
No, I have not.
Okay. And you agree and you understand you are not to apply for a U.S. passport during the pendency of this case or further court evaluation? Order.
Yes.
All right. State?
I'm satisfied as far as that's concerned, Your Honor.
Okay.
And Your Honor,
All right.
is it level 1 as the state request or level 2 as defense request?
It's going to be level 1.
Thank you, Your Honor.
Honor, should I make an announcement or?
Yes, and I apologize. Thanks for your patience.
¿Alguien más necesita traducción al español?
¿Alguien necesita en español un intérprete? Nobody else at Maine requires one, Judge.
Okay, Paul Ryan, do we need a Spanish interpreter?
No, Your Honor.
Thank you, sir. Conte, do we need a Spanish interpreter?
No, Your Honor.
North Broward?
No, Your Honor, we're good.
Okay, thank you.
Sure.
Delton Eric Tompkins. Hello.
Mr. President, Judge?
Morning, you're being held, sir, on a capious misdemeanor for an underlying possession of cannabis.
I've been there. Judge, Mr. Tompkins right now advised me he believes he may have already resolved this case. Is there any way Mr. Lunder can look in Odyssey to see if that's true?
Sure. Or it could be another case.
He's checking right now, Mr. Romero.
That happens. No, this case has not been resolved. He was never arraigned on.
I'm sorry about that.
But if he wants to resolve it, the state's offer be withhold. Court costs, judicial notice, time served.
Mr. Tompkins wishes to accept the state's offer, Judge.
Okay. Sir, please raise your right hand. Do you swear or affirm to tell the truth?
Yes, ma'am.
All right. Is anyone forcing you to resolve your case today?
No, ma'am.
Are you under the influence of any type of alcohol or drugs?
No, ma'am.
Have you ever been treated for a mental or emotional illness which would impair your ability to understand what's going on today?
No, ma'am.
And do you understand you're waiving your right to trial?
Yes, ma'am.
Okay, and you're pleading no contest, is that correct, sir?
Thank you, ma'am.
Okay, I accept your plea. I find it is freely and voluntarily given. The court will withhold adjudication, take judicial notice of time served, and you'll have 12 months to pay your court costs.
What? How much the court cost?
$293. Brandon Haynes? Good morning, sir. You're being held on 2 capious misdemeanors, and you have a hearing set in your division on January 8th at 2 p.m. State?
Your Honor, if Mr. Haynes wants to resolve the matters, Your Honor, the state's offer to be adjudication time served on both counts.
Judge, he wishes to accept the state's offer.
All right, sir. Please raise your right hand. Do you swear or affirm to tell the truth?
Yes.
Okay. Is anyone forcing you to resolve your case today?
Yes.
Is anyone forcing you to resolve your case?
No, nobody.
Okay. Are you under the influence of any type of alcohol or drugs?
No.
Have you ever been treated for a mental or emotional illness which would impair your ability to understand what's going on today?
Yeah, I understand.
All right. Do you understand you're waiving your right to trial?
Yes, I understand.
Okay, sir, and you're pleading no contest to the possession of drug paraphernalia and pedestrian obstruction of traffic? Is that correct?
No problem.
All right, state again, what was your recommendation?
Adjudication time served on each count, Your Honor.
Okay, the court will go ahead and adjudicate on both counts, sentence you to time served, and you'll have 12 months to pay your court costs.
Okay.
All right, good luck, sir. Richard Hilton?
North Broward.
Yes, good morning, Your Honor.
Good morning, sir. You're being held on 3 charges. The first one is trespass, failure to leave property upon order of the owner. Number 2, resisting officer obstruction without violence. And last but not least, sir, you have an out-of-county hold for a civil case. And it appears that you have a purge provision that you'll need to answer to in Hillsborough County.
Your Honor, the state's offer, if Mr. Hilton wants to resolve counts 1 and 2, would it be an adjudication time served on both counts?
Sir, did you want to resolve the first 2 cases?
I would like to resolve them, yes, Your Honor, but I'm also on a fixed income, and I have very limitation as to how much. I don't know what this is going to constitute as far as costs.
Hold on, sir.
I have no problem with the court giving him, I believe you can give him up to a year to pay the court costs, and if he can go to the clerk's office and
Okay, sir, so what we
Work on
can
it with
do is
them.
give you 12 months to pay your court costs. If you're having issues, you'll contact the clerk's office, okay?
Okay.
Okay?
Richard, I want you to contact my office later on today to make sure that the procedure we discussed earlier is actually carried out, all right?
Okay.
All right? Okay.
Okay, sir, please raise your right hand. Do you swear or affirm to tell the truth?
Yes.
Is anyone forcing you to resolve your case today?
No.
Are you under the influence of any alcohol or drugs today?
No.
Have you ever been treated for a mental illness which would impair your ability to understand what's going on today?
No.
Okay, and sir, you're waiving your right to go to trial, correct? Do you understand that?
Yes, ma'am.
All right, sir, and you're pleading no contest to the trespass, failure to leave property upon order of the owner, as well as no contest to resisting officer, obstruction without violence? Is that-
Yes, Your Honor.
Okay. The court, we accept your plea. We find it is freely and voluntarily given. The court will go ahead and adjudicate with time served. Sir, you'll have 12 months to pay your court costs. And then if you have any issue within that 12-month time period, please contact the clerk's office, okay?
What is the amount of the court cost, Your Honor?
$293, sir. Okay? Good luck. Peter Mansour Cesarian. Hello, sir. You're being charged with DUI, alcohol, or drugs, first offense.
Yes, ma'am.
State?
Your Honor, I don't see any criminal, Mackenzie, you don't have any notes, do you?
He doesn't have any arrests within the last 10 years, Your Honor.
So there's a record, just.
Mr.
Judge,
Romero?
I didn't hear that. What was his,
There was no arrest, correct, in the last 10 years?
Correct.
No arrest in the last 10 years.
that confirms what Mr. Kassarian has advised me, Judge. He's
What are
been
you
here
asking
himself.
for?
Judge, we'd be asking you to consider an ROR or, in the alternative standard pretrial on
Okay.
Mr. Kassarian's behalf.
All right.
Your
the
Honor,
court-
and based on the breath result, I have no objection to pretrial.
Okay, the court is going to go ahead and find probable cause, and we will ROR your client, okay?
Thank you, Judge.
Sebastian Esteban.
Mr. Esteban, come on up, please.
Hello, sir. You're being charged with touch or strike battery? State?
Your Honor, I'm showing Mr. Esteban. One moment. Yes. In 2011, at a Martin County burglary of an occupied dwelling, 3 counts of trafficking and stolen property. He was sentenced to 4 years in state prison. It looks like he violated his release conditions and was placed back into state prison. Last year, he was released March 22nd of this year. Based on his criminal history and prior prison sentence, state would be requesting that the bond be kept at $1,000 and an order of no victim contact.
Okay.
Judge, his fiance who's pregnant is gonna be posting his bond, so Judge, we'd be asking you to leave the standard bond in place at this time.
Okay,
Your Honor, in addition to no victim contact, I just asked for an order of no return to the home, I believe it's Home Goods on Oakwood Boulevard in Hollywood.
okay, all right. The court does find probable cause. We'll keep the bond at the standard $1,000. Sir, you're to have no contact with the victim, either direct or indirect. Do you understand?
Yes, ma'am.
You to remain at least 500 feet away from the victim pending further court order. Do you understand?
Yes, ma'am.
You're not to possess any firearms or ammunition. Do you understand?
Yes, ma'am.
And last but not least, you're not to return to the Home Goods in the Oakwood Plaza. Is that correct, Mr. Litton? It's in the
Yes,
Oakwood
yes, Your
Plaza
Honor.
in Hollywood, okay?
Yes, ma'am. Thank you, Judge.
All right, good luck.
I would like to send an alert, right? That's what I'm gonna,
Daniel Kent Phillips.
that's what I'm gonna ask. I'm not making it off. Because he was drunk, but it could be a dual diagnosis situation. Oh, previous mental health.
Ready? Okay.
Yes, Judge.
Good morning, sir. You're being charged with number 1, using 911 to report false alarm or info. Number 2, using 911 to report false alarm or info. Number 3, using 911 to report false alarm or info. And 4, a municipal ordinance. State?
Your Honor, I'm going to be requesting that this case be sent to Judge Lerner Wren's Mental Health Division. I can tell you, Mr. Phillips has been to courts in the past on mental health issues. The allegations in general caused me some concern, and I really think it might do some good for him to see Judge Lerner Wren, because this is also, with what's being described here, a potentially dangerous situation as well.
Mr. Romero? Are you in agreement with the
I
transfer?
understand. No, we have no objection at this time as far as that request from the state. However, Mr. Phillips is 57 years old, he's homeless, he's not gonna be able to afford the $100 bond. We'd ask you at this time to consider an ROR.
Your Honor, Judge Lerner Wren, and I believe there's a memo book up on the desk. I might not be there, but I can tell you as an officer of the court, Judge Lerner Wren from the bench in here specifically made a request that any cases that are being transferred to her division, the bond not be modified.
Okay, all right, sir, so the court's gonna go ahead and find probable cause. We're gonna keep the bond at the $100, and we're gonna transfer this case to Judge Lerner Wren. Terry Ira White?
He's here present, Judge Amain.
Okay, good morning, sir. You're being held on 2 charges. The first one is disorderly conduct, breach of the peace. The second one is resisting officer without violence. State?
One moment, Your Honor. Your Honor, if you want, oh, there it is. Your Honor, I'm not able to make an offer at this time. While he was charged with disorderly conduct on the top count, it does make mention in the report he was going after the other individual, punching him, and the officer's present, and I believe someone from my office should have an opportunity to speak with him before it's resolved. That being said, obviously, the court can take, I just asked the court to make a determination with regard to release conditions. I see he's got a DUI property damage with an enhanced breath and leaving the scene of an accident in 2010. The one thing I would ask, if the court doesn't resolve the matter, is in addition to whatever conditions you set, release conditions you set, that in order of no victim contact or no contact with Latan or Leighton Damon be ordered.
Judge, I understand as far as the state's reluctant to offer a plea offer at this time. Having said that, Judge, he is working at Duffy's and Plantation. He's been there for about 5 years. He's actually subject to he doesn't want to lose his job. He's asking, Your Honor, if you would consider releasing him ROI. His mom is the only person that could disability.
Okay, the court's gonna go ahead and find probable cause. We're gonna release your client ROR. Sir, you're to have no contact with the victim. I believe his name is Leighton, Mr. Linder?
Leighton Damon.
Leighton Damon. Sir, you're not to have any contact with him, either direct or indirect. Do you understand?
Yeah, 88.
Okay, you're to remain at least 500 feet away from the victim until further court order. Do you understand that, sir?
Yes.
And you're not to possess any firearms or ammunition. All right, good luck, sir. Ramon Gonzalez?
Medical reset.
Medical reset, Your Honor.
Giovanni Luke Lucas?
Okay. Your Honor, I will be able to make an offer to Mr. Lucas, and the offer is going to be on counts 1 and 3 and adjudication time served. With the understanding, he cannot go back to these locations. If he goes back and he's brought here before, he will not be getting I don't know what the court will do, but he will not be getting an adjudication time served offer at first appearance from the state again.
Okay, what about with charge 2, sir?
That's a municipal ordinance, Judge.
Okay.
Judge, he wants to accept the state's offer. He wants to abide by the state's condition. My understanding is the state doesn't want him to return to that location. I think that's what I heard.
One
Just want to know what location is it.
moment.
One moment, sir.
Thank you.
Okay. He cannot return to Memorial South Hospital in Hollywood unless he has a legitimate medical issue and he cannot return to 3806 Hollywood Boulevard in Hollywood.
You understand? You can't go back to either place, okay? Yes, sir.
Okay.
He has no problem.
All right, sir, please raise your right hand. Do you swear or affirm to tell the truth?
Yeah, I'm a
Okay.
Yes, ma'am.
Is anyone forcing you to resolve your case today?
No, Judge.
Are you under the influence of any alcohol or drugs?
No, Judge.
Do you suffer from a mental illness which would impair your ability to understand what's going on today?
No, Judge.
Okay. And you understand you're waiving your right to go to trial, correct, sir?
Yes.
All right. And sir, you're pleading no contest to the trespass, correct?
Yes.
And no contest to carrying the open, uncovered beverage in public?
Yes.
And no contest to the trespass of structure and conveyance, correct, sir?
Yes, miss.
Okay, I accept your plea. I find it is freely and voluntarily given. The court will adjudicate you on all counts, sentence you to time served,
Thank you, guys.
and you'll have 12 months to pay court costs. And sir, you understand you're not to return to that location unless you're having a medical issue, correct?
Yeah. Yes, ma'am. Yeah. I have a question, by the way. I have like my license is suspended due to court costs. Is there any way, like, if I start like a payment plan or something, that
You
I
know
can
what you
get my
should do,
license?
sir? Try to follow up with the clerk's office when you get out and see what they can do with you, okay? Because they're the ones that'll have that information for you. All right?
No problem. Have a nice day.
All right, good luck, sir.
God bless.
Christopher Reynoso.
Mr. Reynoso is at the Paul Ryan.
Does he need an interpreter? Your Honor, well, first off, I just want to make, advise the court, I spoke with Mr. Reynoso's attorney, Grant Schwartz. He couldn't be here this morning. Your Honor, I've also been advised by the jail. This morning, we're going to be handling counts 7 through 11. This afternoon, we'll be here on counts 1 through 6.
Okay.
Your Honor, I can tell you, these are all ad charges. I provided the court with the original findings, the information that was filed, and the probable cause affidavit. I'm going to be asking for the court to set bonds in the amount of $15,000 per count with the release conditions. I advised Mr. Schwartz I was going to be making this request. He understands that the bonds were set in the original counts of $15,000. So he's spoken. He wants Mr. Reynoso to know he's spoken with the prosecutor on the case. He's working with him to see if they can agree to a bond reductions. So he doesn't necessarily. He understands that the court sets the bonds at this time at $15,000 per count based on Judge Benson's earlier findings.
Okay, all right, so I'm gonna go ahead and adopt the stipulation between the parties, so through 7 through 11. And I do believe that there's a hearing scheduled in front of your assigned judge on January 9th at 9 a.m.?
And he'll actually be here this afternoon for counts 1 through 6. We just don't have the paperwork.
Okay, all right, sir, so
Well-
we'll see you this afternoon.
All right. Thank you.
Anything else?
And just, Your Honor, are you also placing, I can't remember if Judge Benson, it would be on the findings, if she placed other, yeah, with GPS?
Okay, so
So
I'll,
whatever, I just asked, without going to specifics, whatever conditions she placed on the original counts, I'd ask that they also be placed
okay,
on
we
these.
will do so, thank
Thank you.
you. All right, sir, we'll see you this afternoon.
Yeah.
All right. Thank you.
Yes.
Yes.
And what you do for the, you just post it.
Ryan Patrick Cook?
He's in Conti, I believe, Judge.
Hello, Mr. Cook.
How you doing?
Good. You're being held on a capious felony, and sir, you do have a hearing in your division on January 9th at 9 a.m. State?
Your Honor, just going to request that the $750 bond be kept in place. Mr. Cook has numerous no bond holds on violations of probation, community control.
All right. Mr. Reedy, anything you wanted to add?
No, Your Honor.
Okay, so the court will keep the bond at $750. Good luck, sir.
Thank you, ma'am.
Okay. Christian Cheatham.
North Broward, Your Honor.
Hello, Mr. Cheatham. Let's see, you're being charged with robbery with a firearm, possession with intent to sell, manufacture, deliver cannabis, and possession of cannabis over 20 grams. State?
Your Honor, you may recall Mr. Cheatham appeared before you Monday of this week on, in reference to charges that are mentioned in the probable cause affidavit. I'm going to be asking for a finding of proof evident or presumption great with regard to 16 for first appearance purposes only, and that he be held no bond on that charge and in order of no victim contact.
Your Honor, in light of the fact that Mr. Cheatham is currently being held no bond on other charges, we would defer any argument regarding proof evident presumption great until he can appear before his trial judge, and I explained that to Mr. Cheatham earlier this morning.
Okay, all right. I'm going to go ahead and grant Mr. Reedy's request. And what is your suggestion for bond?
Well, Your Honor, we're asking for a no bond on count 16 with the, for the PBL. The other bonds, I'm fine with the standard bonds.
Okay, anything else, Mr. Reedy?
No, Your Honor, except I advise Mr. Cheatham I'll notify Ms. Chase, who's his ERU lawyer, as to today's developments.
Okay, thank you.
And just no victim contact, Your
Oh,
Honor.
sir, you're to have no contact with the victim, do you understand?
Yes.
Neither direct or indirect. Do you understand? That means
Yes.
by text. Also, you are not to come within 500 feet of the victim pending further court order. Do you understand?
Yes.
And if you are released, you're not to possess any firearms or ammunition.
Yes. All right.
And don't discuss your case with anyone except your attorneys. Okay?
Yes.
All right. Levon George Gibbs.
He is a medical reset, man.
Oh, thank you.
He's also at the very end of your docket, Judge.
Mr. Gibbs? Okay, thank you. Roger Barrera. Hello, good morning, sir. You're being held for a violation of probation felony as well as a capious misdemeanor. You have a hearing for your VOP on January 2nd at 9 a.m. State?
Your Honor, these are court orders, I'm just asking that they be kept in place.
Judge, this only question, Mr. Barrera's only question is in reference to count 2. When was the alleged date of offense on the unlawful assembly?
One moment.
Thank you, Mr. Leonard.
Do you have that date, Mr. Linder?
I've got it right here. September 27th.
September 27th. Ernest James Curse? Good morning, sir. You're being held on 2 charges. The first one is resisting officer obstruction without violence. The second one is you have a capious felony. Okay, and it looks like that was entered by Judge Cholera. State?
Your Honor, since he's got a no bond on count 2, I'm just asking that the $100 be kept in place.
Okay. Court does find probable cause, sir. We'll keep the bond placed in that amount. For charge number 1. Good luck. Ryan Nelson Campbell?
North Broward, Your Honor.
North Broward, Your Honor.
Good morning, Your Honor.
Hello, sir. You're being held on 2 charges. The first one is possession of buprenorphine. The second one is drug paraphernalia. State?
Yes. Your Honor, 2016 possession of buprenorphine. He just got off probation March of this year. Trespass 2014. 2009 possession of MDMA, cannabis, resisting without violence with a violation of probation. 07 possession of oxycodone, drug paraphernalia, cannabis with a violation of probation. Your Honor,
What's your name?
I also show Mr. Campbell, I believe, has an outstanding warrant at this time. Yes. He has a warrant for failure to appear out of the, trying to see what's, out of the state of Georgia for simple assault. Warrant was issued October 27th of this year. He's got priors out of Georgia and Arizona. For all these reasons, Your Honor, I'm asking that the court keep the bond at $1,000.
Mr. Rady?
Judge, I spoke with Mr. Campbell. Even though he's been living here in Florida for 26 years, he doesn't have any money. He's fallen on some really hard times. He's given me the number of his mother and of his ex-wife in the hopes that they might be able to come up with something. I'd ask the court to consider reducing the bond to $500.
Okay, thank you, Mr. Reedy. The court's going to go ahead and find probable cause with regard to charge number 1. The court will keep the bond at the $1,000.
I'll make those for you, Ryan.
All right, that's fine. Have a great day.
All right, good luck, sir.
Judge, if we could address one matter here at Maine.
Okay.
The gentleman that we just previously spoke about here at Maine was Mr. Ernest Kierce. What was before you was a misdemeanor resisting without. We do understand on count 2 the capias for the felony. Your Honor can't do anything about it, but Mr. Kierce respectfully would ask if you would, on count 1, consider resolving it for time served.
Mr. Linder, you're ready,
Your Honor,
to say something?
well, no, Your Honor, frankly, I'm not able to make an offer, and considering he's got a no bond hold on an aggravated battery, I mean.
Respectfully, I'm going to decline your request at this time, Mr. Romero.
Yes, Judge.
Ivan Alonso Villavalta.
Come on up, sir. He's approaching, Judge.
Thank you. Good morning, sir. You're being held on 2 violation of probation felony cases, and you have a hearing scheduled in Division FF for your violation of probation on December 26th at 8:30 a.m.
Thank you, Judge.
All right, good luck, sir. Junior Eve Augustave.
Hey, ma'am.
Hello, sir. You're being held on 3 charges. Number 1, leaving the place of safety. 2, probation violation or community control. And 3, violation of probation felony. Sir, you do have a hearing scheduled in Division FK for your violation of probation on January 4th at 8:30 a.m. Timothy Demetrius Nelson?
Mr. Nelson?
Good morning, Mr. Nelson. It looks like you're being held on a violation of parole.
Yes, ma'am.
Anything state?
No, Judge.
Okay.
Good luck, sir.
Jonathan Rico Booker.
He's here, President Maine, Judge. He's approaching.
Good morning, sir. You're being held on 2 charges, grand theft auto and fraud uttering a false instrument. State?
Yes, Judge. Your Honor, I'm showing in 2015, Mr. Booker pled down a felony to petty theft.
Mr. Romero?
Judge, the only priority he has is a petty theft. He did give me the phone number of 2 of his friends that could potentially post his bond. The only thing I'd be requesting, Judge, I'm going to be calling his friends, so hopefully they can afford to post his bond. On reference to count 2, would you consider an ROR so that the total bond would be $1,000?
Okay, sir, the court's going to go ahead and find probable cause with charge number 1, sent it bond at $1,000 with regard to charge number 2, ROR.
Thank you, Judge.
You're welcome. Jake Michael Maldonado.
We would waive formal reading of the charges, Judge.
Okay. Hello, sir. Your attorney has indicated that we are going to be waiving the reading of the formal charges, but I will just say that you're being held on 12 separate charges. So let me hear from you.
Yes, thank you, Your Honor. The state is going to be seeking no bond holds on counts 1 through 11, the capital offenses, Your Honor, arguing for first appearance purposes under Isaza v. State that there's clearly proof evident or presumption great based on this lengthy and detailed probable cause affidavit, Your Honor. The alleged victims gave specific details as to the incidents. To corroborate, they kept a calendar documenting the dates of the incidents, which the detective observed and noted, and she gave specific notes from the calendar in the report. And last but not least, Your Honor, according to the report, Mr. Maldonado confessed to these offenses.
Mr. Romero?
If I may, Judge, I don't concur with Mr. Linder on the strength of this probable cause affidavit. Just because it's a lengthy probable cause affidavit does not mean that it gives rise to a standard of proof evident presumption great, the highest standard that we have in the criminal justice system. I would note that initially these individuals denied that anything ever happened. It's only after they later have another consultation with other individuals that they come forward with the story. So the fact that they initially denied everything, I think alone is enough to defeat the state's argument that this is proof evident presumption great. I'm not saying that's not strong enough to get to a jury, but it's not enough to meet that standard. The medical evidence in this case, as the examining physician notes, may have been caused. And that's because in these type of cases, and I've handled plenty of these type of cases, no treating physician is ever going to say for certain what the cause of certain type of injuries would be. The state is asking you to hold Mr. Maldonado without bond on this case, and yet we don't even know what it is that he told the police. The last line of this probable cause affidavit says he gave a confession. It doesn't go into any details about what he said. It doesn't, and the state hasn't bothered to play the alleged confession for you. They don't have a transcript of it for you to look at. We have no idea what he told these police officers. Anyone can categorize something as a confession. It doesn't even say he admitted to anything. It's a confession. And I've had plenty of cases, as the court I'm sure is aware, where detectives say, it's a confession, and really it's not. It's really a statement, not a confession. So we don't even know what the contents of that are. I understand the gravity of these charges, and I understand that the court is free to set bond within reasonable parameters for Mr. Maldonado, but this is not proof evident presumption great, and I would ask the court to set a bond in these cases.
Your Honor, if I could briefly reply. One, as far as in response to Mr. Reedy's argument, both victims gave explanations for why they said what they said at first and didn't. And as the court is also aware, and I'm sure Mr. Reedy is aware from the many cases he's tried, that is very common among children. Secondly, Mr. Reedy stated that the results of the physical examinations were inconclusive. That is not true. And I'll read from it. Specifically for one of the alleged victims, the exam was positive for sexual abuse. The other alleged victim, it was may have been caused by sexual abuse or by other mechanism. And I want to be very clear, the specific language used by the detective is not that Mr. Maldonado provided a confession. He provided a full, detailed confession, and certainly it is implicit in that he wasn't admitting to a theft, he wasn't admitting to a burglary, he was admitting to the offenses that he's charged with today.
Okay.
Well, certainly the detective could have said that if that is in fact what Mr. Maldonado had told him. And again, as Mr. Linder also knows from having handled many of these cases, these physical exam results, witnesses never get on the stand and say for certain that this is the cause of the injuries that they observed. And that's why it is not proof evident presumption great.
Okay, sir. Your attorney has declined the reading of the formal charges, so I will just let you know that with regard to charges 1 through 11, I have reviewed the probable cause affidavit filed in your case. I find probable cause. I further find the proof of guilt to be evident or the presumption great. Therefore, you're to be held without bond until further order of the court. Now, this order is without prejudice, sir. Your attorney may file a motion to set bond with the assigned division judge and request a hearing under State v. Arthur. With regard to charge number 12, the court does find probable cause and will keep bond at the $2,500. Sir, you're to have no contact with the victim, either indirect or direct. Do you understand?
And Your Honor, just so there can be no confusion, I'm just going to state on the record, no contact with alleged victims JC and MC.
Okay. Do you understand that, sir? Okay, you're not to come within 500 feet of the victims until further court order. Do you understand that? And then if you're released, you're not to possess any firearms or ammunition.
Yeah.
Okay. Gregory Thomas Leaks? Hello, sir. Okay, sir, we have 6 charges. The first one's an out-of-county hold. The second one is another out-of-county hold. The third one is another out-of-county hold. The fourth one is a capious misdemeanor, fifth one capious misdemeanor, and sixth one capious misdemeanor. Sir, you do have a hearing in your division, which is MT, on January 8th at 2 p.m.
Well, you want me to? Judge, it's me, Mr. Leaks. He's advised me in reference to, he knows he can't do anything in reference to count 1 and 3. I believe it's from Palm Beach. Yes. So that he can hurry it up and be, I guess, picked up from, by Palm Beach so he can go ahead and take care of those matters. He's asking, Your Honor, if you would consider resolving counts 4, 5, and 6 today.
State?
One moment, Your Honor, please. Well, the only issue with resolving 4, Your Honor, and I'll check, if he's a habitual offender, if he's on a 5-year habitualization, he resolves it, my understanding is that kickstarts a new 5-year habitualization.
Okay. Mr. Romero, does your client understand the implications?
Yes, ma'am.
And additionally, because I see counts 1 through 3 are felony offenses, if he ends up resolving those matters, these will add points to his score sheet on those offenses. And I have no idea what he scores.
Judge, he understands and he still wishes to see if Your Honor would consider resolving his cases today on 4, 5, and 6.
Okay.
She's gonna ask a question.
Your Honor, I'd offer him adjudication time served on the counts.
Okay, sir. Please raise your right hand. Do you swear or affirm to tell the truth?
Yes, ma'am.
Is anyone forcing you to resolve your case today?
No, ma'am.
Are you under the influence of any type of alcohol or drugs?
No, ma'am.
Have you ever been treated for a mental or emotional disorder which would impair your ability to understand what's going on?
No, ma'am.
Do you understand you're waiving your right to trial?
Correct.
Okay, and sir, you're pleading no contest to the 3 charges?
Counts 4, 5, and 6.
Yes, sir. 4, 5, and 6.
Yes, ma'am.
Okay, sir.
Yes, ma'am.
I accept your plea. I find it is freely and voluntarily given. The court will adjudicate on all counts, sentence you to time served, and you'll have 12 months to pay your court costs.
Thank you.
All right, good luck. Haig de Paula Petrov.
Is your present, Judge?
Okay, sir, there's 7 charges. The first one is grand theft. The second one is grand theft auto. The third one is resisting officer, obstruction without violence. Number 4, driving while license suspended, habitual. 5, leave scene crash involving damage. 6, burglary on occupied dwelling. And 7, grand theft. We're going to hear from the state first.
Okay. Your Honor, the state is going to be requesting bonds in the following amounts. I'm fine with the standard bonds on, I'm fine for the standard bonds. On count 6, I'm going to be asking for a bond in the amount of $15,000. Noting first off, in the first report, it would appear that, well, never mind, Your Honor, I won't get into that. But, Your Honor, this did involve breaking into someone's home. I do consider that to be more serious than other types of burglaries since people do deserve to feel safe and secure in their homes and that their homes aren't being gone into by strangers. So he does have priors. I see he has a pending possession, misdemeanor possession of cannabis with the DWLS. Another pending possession of cannabis in DWLS. Possession of cannabis 2015, reckless driving 2015. End of record. Mackenzie, did you have anything?
Mr. Romero?
Mackenzie.
Judge, and speaking of Mr. Petrov, he's been here since he was like 10 months old. He's 22 years old. He's gone to school here in this community. Right now, he is working. He has 2 jobs. He works for a company called Oceans Elite. He pours concrete. He's been doing that for about 7 months, making about $13 an hour. He also works for a pest control company called Forever Be Gone. He's been there for about 3 months, making about $10 an hour. Right now, he's living in Pompano with his mother and his 2 brothers. His portion of the rent is about $570. From what he's advising me, his family nor him can post any sort of monetary bond. He's asking Your Honor if you would consider releasing him on all counts on pretrial release, Judge.
Okay, thank you, Mr. Romero. Okay, so the court does find probable cause on all the counts. With number 1, bond will be set at $1,000, 2, $1,000, 3, $100, 4, $750, 5, $100, 6, $5,000, and lastly, 7, it'll be at $1,000.
And, Your Honor, just ask for no return to the residence that's mentioned as the alleged burglary.
Okay, sir, you're not to return to the address of the alleged burglary. Do you understand that?
Yes, I do.
Okay, you're not to come within 500 feet of that home.
Okay, that's not a problem.
Okay, thank you. Luis Montoya?
Mr. Montoya is here present, Judge. He declined to serve as a public defender, Judge.
Okay, sir, are you sure you don't want Mr. Romero's services?
I'm gonna get my own attorney.
Okay, do you want to continue this case? Are you hiring an attorney today? We can reset this?
Yeah, I'm gonna talk to my attorney when I get out,
Okay,
if I get out.
okay, sir. You're being charged, there's 4 charges. The first one's aggravated battery on an officer, firefighter, EMT. The second one is aggravated assault on officer, firefighter, EMT. The third one is resisting officer, obstruction without violence. And lastly, the 4th one is careless driving. State?
Yes. First off, Mr. Montoya is out right now on a $500 bond for battery. So he's out on a violent offense, and now he's before the court alleged of attempting to strike one officer with his motorcycle and then using his motorcycle as a weapon and attacking another officer. I'm very concerned for the safety of the public. This is now 2 violent allegations against Mr. Montoya this year alone. Your Honor, I'm going to be asking for bonds in the amount of $15,000 on 1, $10,000 on 2. Should he post his bond, that he be supervised by pretrial release with a GPS monitor.
Okay, the court's gonna go ahead and find probable cause with regard to charge number 1. Bond will be set at $15,000. 2, bond will be set at $10,000. And 3, bond will be set at $100. Sir, if you do post bond, you will be out with the GPS locator on pretrial.
Okay.
Okay, good luck. Robert Christian Cotto?
He's posted bond, Your Honor.
Okay, thank you, Mr. Reedy. Ramon Garin Benjamin?
Mr. Benjamin's here present, Judge Amain.
Hello, sir. You're being held on 2 charges. The first one's aggravated assault with a deadly weapon without intent to kill. The second charge is aggravated assault with a deadly weapon without intent to kill. State?
Yes, Your Honor. And Mackenzie, if he has anything else other than what I provide the court, could you please? Your Honor, Mr. Benjamin's priors, 2017, unlawful use of false name ID, possession of cannabis. 2008, possession of cannabis with intent to sell, possession of drug paraphernalia with a violation of probation. Your Honor, based on the allegations in this case, the state would be requesting bonds in the amount of $25,000 per count. Specifically, since there was an allegation that a firearm was used, Should Mr. Benjamin post his bond, that he be placed on pretrial release supervision with the GPS monitor, that he be ordered not to have any victim contact, and that he also be ordered not to be in possession of any firearms, weapons, or ammunition until further order of the court.
Mr. Romero?
Judge, I've seen Mr. Benjamin. He's been residing in South Florida his whole life. He's 27 years old. At this time, he's working. He works for a company called Allegiance Crane. He's a crane operator. He's been there employed for about 2 years, making about $15 an hour. He's living in Tamarack. He lives there with his fiance. His fiance is pregnant at this time, relying on Mr. Benjamin as far as his health insurance. Right now, they're renting an apartment. Their monthly rent is about $1,200 per month. They've signed a 12-month lease. From what he advised me right now, his fiance is a telemarketer. That's the only person that he's going to be able to contact to help post his bond. But from what the state's suggesting as far as a monetary bond, he's not going to be able to afford to post that. He has no sort of objection, as far as Your Honor, imposing any sort of a pretrial release on him. He'd be asking you, though, however, to consider reducing the bond to $2,000 on each count. That would make it a total of $4,000 with pretrial release. My understanding is he doesn't have any significant priors. He's been here his whole life. He's going to be coming to court. He just needs to work in order to provide for his fiance and his future child, and they need his health insurance so she can properly go to the doctor. I'd ask you to take that into consideration, and that's why we requested what we requested, Judge.
Okay, the court's gonna go ahead and find probable cause with regard to charge number 1. Bond will be at $5,000. Charge number 2, bond at $5,000. Sir, if you do make the bond, you're gonna be out on pre-trial with a GPS locator. And sir, you're to have no contact with the victim. Do you understand? Neither direct nor indirect. Do you understand?
Yes, ma'am.
Okay, you're not to
Judge,
come within,
I'm sorry.
you're not to come within 500 feet of the victim. Do you understand?
Yes, ma'am.
And you're not to possess any firearms or ammunition pending further court order. Okay, Mr. Romero.
The only thing I'd ask, as far as a clarification, that's level 2 so that he could still work, correct?
Yes, level 2.
And Judge, I believe there's a cost associated with the GPS as far as $5 per day. Considering their financial situation, his fiance's pregnant, would you waive the $5
Yes,
a day
we'll waive that cost.
Thank you, Judge.
Stanley Ivy?
Your Honor, he's a reset, he's missable.
Oh, thank you.
Reset proceeding.
Okay.
Is it, L'Oreal, what's?
William Gonzalez?
It's a distinction with no difference.
Gonzalez is approaching, Judge?
Good morning, sir. You're being
Morning.
charged with grand theft, state?
One moment, Your Honor.
Yes.
This guy was a loss prevention officer. Still. Yeah, I'm not showing any record.
We don't have any record. What say you, Mr. Romero?
Judge, she informed me that his mother knows that he's here and that his mother will be posting his bond.
Okay, so he prefers that over pretrial release?
That's what I talked to the lady before with the pretrial thing. They said you're coming up care of the whole bond. I was out there with that woman out there because I had no fires. And I agreed about doing a pretrial and that they would cover.
Do you want to do pretrial?
Yeah, don't we? Yeah.
Okay, I guess, having a change,
Okay,
he
all
wants
right.
to do pretrial.
Okay, so the
Yeah,
court
I
does
spoke-
find
I spoke
probable
to the
cause. Yep, we have the information, sir. So Mr. Romero now knows as well, so the court's gonna go ahead and release you on standard pretrial.
I'm gonna get you a Mac. As soon as you leave here, you have to go to that location. Here you go. Okay, just across the street. See, you're here, main judge, walk across the street, go there. As soon as you release, you go over there, okay?
Jeremy Blake Bonovicino?
Medical reset.
Medical reset, Your Honor.
Lavon Gibbs?
He was on the docket earlier, Judge. He's a medical reset.
That's right.
He's a medical reset also.
Garrett
Robinson,
Luke Robinson?
Yes. North Broward, please.
Hello, sir.
Hello.
Okay, you're being held on 3 charges. The first one is possession of a controlled substance without a prescription. Number 2 is resisting officer, obstruction without violence. And lastly, trespass, failure to leave property upon order of the owner.
I don't believe he has any criminal.
State?
I don't believe he has any criminal history, Judge.
Okay.
I don't believe there's probable cause on count 1 either. Doesn't indicate that these pills were tested.
Your Honor, the officer can rely on his statement, the very last statement. He can certainly rely on Mr. Robinson's admission in making the
Well,
arrest.
Mr. Robinson's not a chemist. Are you a chemist, Mr. Robinson?
No, I'm not. I'm an accountant.
He doesn't
Okay.
have to be a chemist. Certainly, one
Okay.
can rely, and someone knows what kind of pills they have on them.
All right, so the court's going to go ahead and find probable cause on all counts.
I'd
and
consider,
ROR.
yes, thank you, Judge.
My pills to make sure I'm taking.
Mr. Robinson, you're going to be released on your own recognizance, but that doesn't mean the case is over. You're responsible for checking on your court dates to make sure you come back to court if and when charges are filed, okay?
Yes, sir.
How'd you get that shiner? Was that part of your arrest?
Yes.
Make sure somebody takes photographs of it.
Okay.
Or take a selfie, whatever you got to do, but document it, okay? Okay.
And if I,
Go ahead, sir.
and if I provide prescription, for that, then,
Talk to your attorney about it.
You'll talk to your attorney about it, sir, okay?
okay.
All right,
Thank you.
no problem. Michael Anthony Turner?
Mr. Turner's here, President Judge of Maine. Judge, first question in reference to this case number 17-010502 CF10A. He believes he has regional counsel. Is there any way to clarify that?
Sure. Mr. Linder, can you check?
Sure.
And Mr. Romero, if it is regional counsel, do you want it reset for the afternoon?
Oh, no, I have no voice in the game. That
Okay.
would be Mr. Turner's
Okay.
decision.
Yeah, I'm showing he's represented by Ernst Olivier, who I believe is with Conflict Counsel.
Yeah, Mr. Olivier is conflict counsel.
Looks like he was arraigned 11 days ago by Judge Duffy.
Okay, so what we can do is we can reset this for this afternoon, sir, and we can contact Mr. Ernst for you to let him know that you have a hearing.
Okay.
Okay?
Okay.
All right, thank you, sir.
In the afternoon.
Mr. Linder,
Yes.
do you mind contacting Mr. Ernst? Okay, thank you, and we'll
Yeah,
call it later.
I'm on it.
Okay. This will be reset.
Ernst Olivier, please.
Demetrius Richardson.
One of his
Mr.
clients.
Richardson is here, President Judge of Maine.
Okay, good morning, sir. You're being held on an aggravated assault with a firearm, another aggravated battery with a firearm, and lastly, you have a KPS felony.
around?
Sir, you do have a status
Ernst Olivier?
in Division FB,
Okay, thank you.
January 9th at 8:30 a.m.
Your Honor, what I'm going to be requesting, when he first went before the court, he was charged with aggravated assault with a deadly weapon. Your Honor, can I have a moment, please?
Oh, yeah, we just need one moment, okay?
Yes, Judge.
Hey, we have the defendant this morning, Michael Turner, is being represented by Ernst Olivier.
Just so you know, Judge, Mr. Olivier is out until January, so he will not be able to join us this afternoon.
Okay, we'll try to get another,
I'll try and see if we can get somebody over here.
right, thank you so much.
Okay. Your Honor, these were technically upfiled to aggravated assault with a firearm, but considering that when Judge Canner set the bonds, the weapon that was allegedly used for his consideration was a firearm, I'm asking that the same $10,000 bonds be kept in place. He has also been charged with possession of a firearm by a convicted felon. Just to advise the court.
Okay, and you're asking the court to keep the bonds at the 10,000,
For
correct?
those two counts, yes. He also, just so the court knows, he also has I believe he's also being held for home invasion, robbery with firearm, no bond. I'm gonna ask that a $5,000 bond be placed on the firearm offense.
Okay, okay, so the court's gonna go ahead and find probable cause. And we're gonna go ahead.
Mr. Richardson is only inquiring, he wanted to know as far as when this case was filed, or if it's filed.
We're here because it's filed.
Could you give us
It's
the
like
date?
this, it looks like December 5th to me.
December 5th, sir. All right, so the court's gonna go ahead and find probable cause, and we'll adopt the state's recommendations to keep those bonds at 10,000, and then the other one for 5,000. Anything else?
No, Judge.
All right, good luck, sir. Jason Perez.
Good morning, Your Honor.
Hi, Mr. Perez. You're being charged with battery causing bodily harm, domestic violence, state? Yes, madam.
Why was this, why was? I don't even have the paperwork on him.
Hold on, sir. They're just looking, reviewing some paperwork, okay?
This is a change of charge, you're telling me? Okay, one moment, Your Honor.
Mr. Linder, do you want to see my paperwork?
No, the paperwork I'll be able to get in a moment. I'm just trying to catch up, like, with the
Okay.
procedural history.
All right, please, we'll give you a moment then.
Thank you, I appreciate that, Judge. Your Honor, Judge Orlando originally set his bond, he was arrested for battery. We've
Okay.
upfiled it because Mr. Perez has prior batteries, so he was charged with felony battery priors. Judge Orlando set his bond at $25,000 in order to no victim contact. I can advise the court, Mr. Perez, in 2009, he was convicted of aggravated stalking. He violated his probation. He was sentenced to just under 40 months in Florida State Prison. 2008, he was convicted of 2 counts of battery, misdemeanor stalking, criminal mischief. 2000, possession of alprazolam. Your Honor, I'm not asking the court, even though the case was upfiled, I'm not asking the court to increase the bond. I'm just asking the court to keep the bond at $25,000 and that a new no contact order be issued for the alleged victim, who is Jennifer Childs.
Okay. Mr. Reedy?
Yes, Judge, I didn't get a chance to talk to Mr. Perez because he was kind of a late add-on to the docket, but correct me if I'm wrong about any of this, Mr. Perez. He's lived in Florida 39 years. He does have extensive family here. He could live with his brother in Coral Springs. He is in good physical health. Are you working right now, Mr. Perez?
Yes, sir, I work for myself doing air conditioning work.
How long have you been doing that?
For about 2 years, sir.
You gonna be able to post a 25, would you ask 25,000?
That's what
No,
they're
sir, I
asking.
won't be able to do that.
How much of a bond do you think you could post?
Right now, nothing. I was, wanted to request, I've been here in custody 42 days, and I wanted to know if I could get a ROR. I have a family to support.
And why don't you tell us more about your family? Who's in your family?
My, son, that he's 2.5 years old, Gabriel Perez, which the mother is, Jennifer Childs.
Well, you know you're not allowed to have any contact with them.
Yes, sir, I understand that, and I will obey the contact order, by living with my brother. And I would, I applied to the court orders. I got this, case dismissed, with my first domestic violence against her, that I got bonded out, and they released me. I got out on bond, and I came to court and did what I had to do. And my second charge against her in 2015, it got dismissed also.
And you'd come back to court for all your future court appearances?
Yes, sir, like I said, that I did that on my first, domestic violence
Okay.
charge. And
All
I
right.
came to court. I had no reason to run, sir.
Your Honor, there's a 39-month or almost 40-month prison sentence that's evidence that he doesn't follow court orders because he violated an injunction in that aggravating stalking. Secondly, Your Honor, the only reason he's even before the court is because the state took a misdemeanor offense and filed a felony offense. This wasn't as a result of the defense filing a motion to modify his bond. I don't think rationally it would make any sense to give him a bond reduction because the state filed a more serious charge and he's now facing more serious
Okay,
consequences.
thank you. The court's gonna go ahead and find probable cause. We'll set bond at $25,000. Sir, you're to have no, contact with the victim, either direct or indirect. Do you understand?
Understood.
And you're not to come within 500 feet of the victim pending further court order. Do you understand?
Yes, Your Honor.
And you're not to possess any firearms or ammunition. Do you understand?
Yes, Your Honor.
Okay, good luck, sir.
Thank you very much.
And Judge, are we starting at 1 o'clock today?
Yes.
Thank you, Judge.
All right, thank you, Mr. Romero.
All right, we'll see you folks at 1. The exact same time that the public defender's office is closing today.
Oh, nice.
We're starting at 1? Yeah. I don't have it yet. You don't have it yet? No. You don't have the PCs on those yet? No. What did I do with my SBU? Oh, here they are.
Thank you.
Yeah, no. I won't even get emailed them at least for like another hour, if not later. They're usually slow on Fridays.
Yeah, 1 o'clock.
It just. It's very fast. And the one thing you can take from here is a lot of shit happens in there that doesn't. As you just saw.
Yeah.
Yes.
But because what happens is, okay, there's a bond schedule. And part of the bond schedule is on certain offenses, including any domestic violence case, you're held no bond until your first appearance. Okay. So when we took the domestic violence battery and filed it as a felony domestic violence battery, they have to put the new bond schedule on.
Right.
Which is
No bond.
magistrate. He's entitled to a bond. So they schedule him in here. Now,
It's like ridiculous.
Judge? No, it's for me too. I want to be able to say stuff without having it recorded, so it's my own interest that I'm asking.
I don't miss handling those kind of cases anymore, Eric.
I'll tell you, that's amazing that those girls had the forethought. I mean,
That calendar
that
stuff is-
calendar's gonna.
Wow.